It is June 25th of 2026, and this is the Court Gallery. Coming up, things get explosive in Judge McNally's courtroom when a defendant's plea deal implodes as he tries to argue his bond from county jail. Then, Judge OAKLEY hears directly from a victim on Zoom detailing a frightening nude assault by the defendant standing before him. Later, Judge Stewart must resentence a man for a 35-year-old murder. But his recent prison record, which includes assault, indecent exposure, and getting caught with prison-made Spud juice, gives the court serious pause. It all wraps up with Judge Ricke untangling the sentencing for a man's multi-county crime spree. All that and more starts right now.
And it was a great learning and eye-opening experience. I have no criminal record before this, and I will not ever be a criminal after this. Again, I am sorry for my actions which have led me here, and I learned a lifetime lesson. I'm sorry if this has any negative effect on the plaintiff. I didn't mean to cause any harm or stress of any kind to the plaintiff. Thank you, Tom.
I think what bothers me is that she made an initial report in January and you still kept contacting her, and she goes back at the end of March. She blocked you, according to her, from her phone. And then she's saying you use burner phones or different numbers to contact. She said you contacted her 200 times. They got you on a Ring camera, banging on her door. Now, she says this is after she told you to stop contact. So, I mean, I have some real concerns when I read this report, the pre-sentence and the police report today. I mean, I give you credit. You've been law-abiding. You granted an honorable discharge from the Army, correct?
The Air Force, sorry, yes.
The Air Force, I'm sorry. But you're jeopardizing what you have going on here by continuing to contact her. I mean, you got a pretty good job. You're going to have a pension over there, I'm sure.
Yes. And
I don't expect you to contact her at all. And some of these are scary. She described it as scary, but when you're saying, when she's telling me, or telling the police at least, not telling me, but in this, where'd she say, according to Susan Bryan, has left messages advising her that he is admirer of Hurock Park, which he knows Susan frequents. She sought therapy over the situation. Her email here does not appear to be vindictive to me in any way. I mean, my hope is not simply for punishment. I'm paraphrasing. I hope Brian receives the help, support through therapy he so much needs to address these issues. I'm not the first woman he's followed and harassed. I hope that this serves as a meaningful lesson and an opportunity for personal growth and positive change. My sincere hope is that Brian learns from this situation, heals and makes better choices and won't repeat this behavior toward another woman. So she sure doesn't sound vindictive to me. This isn't the situation that I see sometimes where a couple is divorcing and neither one of them feel that the other one deserves to breathe air on the planet. It doesn't seem like that's the case here. So I'm just telling you, I have real concerns here. I'm not going to order a GPS tether. I don't have any proof to substantiate that you were charged in other cases and convicted in other cases involving the same or similar type behavior. But I just want you to know, I'm not going to come across as threatening you, but if I find out there's any contact here, you're not going to like what I'm going to do. I'm going to place you on probation for a period of 12 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as direct. I'm going to order that you not have any contact with Susan Sherbrick. You cannot write, phone, see, text, email, or communicate with her or have anybody else do any of those things for you or on your behalf. I'm going to order that you not possess any firearms or dangerous weapons. People in the military in the past usually have them. I'm going to order you surrender them to the Flat Rock Police Department. No firearms.
I surrendered them to someone else.
Who?
And I've met Carlo before too.
What's that?
I've met Carlo before. She's been in my office. That's who you surrounding the guns to.
Yes.
She has, Steve wanted her to come up here and swear to that.
Where does she live? Where does she live, sir? Mr. Crane, does she live with you?
No.
Are you friends?
Yes.
How close to your house is she?
Mark. Where do you want, Judge?
Yeah, I'm going to have you surrender him to the Flat Rock Police Department. Surrender to the Flat Rock Police Department. Make sure you call over there and tell him that's what I'm going to order. If you would please, Heather or whoever's done, surrender by end of day. And I want them to hold him during the pendency of this case. I'm going to order that you serve 5 days on the court with Berwin. And there's a $35 a day charge for that for a total of $175. $100 fine, $100 cost, $75 victim's rights fee, $50 justice assessment, 3 1/4, screening fee 60 for 385, probation fees are 240 for 625. The total here with the court work program fees is $800. If you violate your probation, you could be revoked, you could be incarcerated for 90 days, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. I mean, I have to tell you, I actually contemplated ordering a GPS tether here. I don't want you being near that lady. If you're in the store, as an example, at Meyer, and you see her there, you're to leave your cart right where it is, and you're to walk out of the store. If you see her at Hurock Park, you're to leave your cart there, or I'm sorry, you're to leave there immediately. So no contact at all with Miss Sherbrooke, and you're not to go within. You don't live in a location within 2 miles of her, do you?
No, sir.
You're not to go within 2 miles of the victim's residence. I'm not going to order a tether of the victim's residence or place of employment. You understand that?
Yes, sir.
We'll give you a review hearing date. If you're compliant, you don't have to show up counsel. He can just come and the case would be dismissed. If you're not compliant, you better hire your lawyer. You did a good job for you. Give me a date, if you would, Heather, in 12 months, so we can go early June, late May of 27.
Okay, that will be June 24th.
June 24th of 27 at 8:30 in the morning. And sir, can you pay all of this today, or do you need some time?
I need some time.
How much do you have today?
Okay.
All right, we'll pay $500 today. I'll just let you pay $100 bi-weekly, and I'll start that beginning on July the 13th. Is that good? If you don't have the money at any point, no problem. Don't be alarmed. Call the court. We'll go on Zoom, or you can walk in here on before the due date, 8:30. Be glad to give you an extension. Just don't ignore me, okay?
Yes, sir.
All right, best of luck. Thanks,
Which
counsel.
to you, Judge, I just want to state something beforehand. When you go to they always place this on the record. When you go to the police station,
The gun should be unloaded too.
and in the trunk, what I tell them is go in, they come out.
Right, exactly.
That's right.
So that's what I'm, so apprise them. Tell me when you're going to go. You going to go today?
Yes, sir.
What time about?
Well, I live in Belleville, so
So tell him he'll be there around 1. Is that good?
1 o'clock today.
yes.
Or earlier or later?
One's fine.
1 o'clock. Tell them about 1, Heather, that Mr. Crane will be there, and he's not going to have any guns. He's not going to bring them in. He's going to go in and tell them. They're going to come out and they're going to confiscate the guns. Thank you very much. Have a good day. Thanks, counsel. And you'll meet with probation before you leave here. Robert Eugene Williamson, 26F245-827 A and B.
P78413, MIDC counsel for Mr. Williamson.
Sir, your name?
Robert Eugene Williamson III.
All right, so we have an operating with the presence of drugs, and we have a resist, hinder, and obstruct an officer. Something must have bothered me if I set a bond like I did. That at any rate, he's going to plead guilty to operating while visibly impaired. The prosecutor then will move to dismiss due to the consumption of drugs. The prosecutor will move to dismiss the operating with the presence of drugs and the resist, hinder, and obstruct. True?
Yes, sir.
If you plead guilty here, sir, to that charge of operating while visibly impaired due to the consumption of drugs, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all 4 points. License suspension or revocation in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes, I do.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial by court or jury. You have the right to question their witnesses, to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses and to testify if you so choose, or remain silent. If you remain silent, the jury would be instructed that they cannot hold that against you. You do, however, have the right to testify also at a trial. If you plead guilty, you're giving up all those rights and you're giving up your constitutional right to a jury trial. Do you understand that?
Yes, I do.
You still wish to plead guilty?
Yes. Yeah.
To the charge operating while impaired due to the consumption of drugs. How do you plead?
Guilty.
Were you operating a motor vehicle on Telegraph near Ypsilanti and Flat Rock, February 5 of 26 at 1:59 p.m.?
Yes.
Prior to that, did you consume some drugs, including meth and amphetamines? Is that true?
Yes, I stored a lot of.
And you were under the influence of that at the time you were operating the vehicle, correct?
Yes.
Why were you pulled over by the police? What were you doing wrong in your operation of the vehicle? I mean, were you swerving, speeding?
There was improper lane change, and they had a report from, I believe, the gas station that he was at.
All right. And so how did he what did he do then?
He basically pulled out of the gas station and not into the proper lane. You're supposed to pull into the right-hand lane. He pulled into the next lane over. That was one of the reasons of reasonable suspicion. There were other things in the report. There was one other thing in the report that led them to pull him over.
Did you do that, sir? Pull into the wrong lane like your lawyer just described?
Yes, I did.
And counsel, do you see the toxicology report reflects the presence of these?
Yes, I spoke to Mr. Williamson. I did review the results with him, and he does not contest.
Are you on probation or parole, Mr. Williamson?
No.
Anybody forced to plead guilty?
No.
Please accept it that impaired due to the consumption of drugs. Resist obstructs dismissed. The OWPD is dismissed. I'm going to refer you for a screening and assessment. Are we going to do this on the 23rd again, Heather?
This one we can do on Tuesday, the 14th.
July 14th at 8:30 in the morning will be your
Judge, this one's our afternoon docket, so we could do this one at 1 p.m.
At 1 p.m., sir. July the 14th. July the 14th at 1 p.m. So probation is going to be notified. They're going to go on there. They're going to talk to you. And we'll go from there, okay?
Okay.
I will be back in court on the 14th.
Good.
You would ask the court to release Mr. Williamson.
Well, something bothered me here.
Yeah.
Your name?
There was if I could explain.
Okay, well, wait a minute. Let me get his name.
Morning, Ron.
I don't know if you need to review this or not, but I don't set 40,000. 40,000. How many priors he have?
I saw it on YouTube. There was a problem, Your Honor, when he was having his arraignment. He could not hear. There was something glitching on his end as far as the Zoom.
I didn't.
Kept seeing other, and he was basically irate about the fact that he couldn't hear the proceedings and that he made some unfortunate comments.
What kind of comments?
I think he used the F-bomb at some.
You didn't do that, did you, Mr. Williamson? You know you're in a courtroom. You're not at a strip club. You know
He
that,
wasn't
right?
directing it at you, Judge, but he was.
He wasn't directing it at me. He was talking to me,
I
wasn't he?
understand. He was in your courtroom. and he
Wasn't
said-
directing it at me, though.
I mean, he didn't. I take that back. He used the F-bomb in your courtroom, and that's.
It's not my courtroom, but thank you for the compliment. Listen,
I wasn't present for that, so I'm not aware of any bad behavior by this defendant. I will leave it to the court's discretion regarding that.
let me see what he's got here. He's got a bad record, huh?
Oh, 13 years old though. I haven't been in trouble in 13 years in Michigan. I can
You
change my
made up
life.
for it by what you did your first few years as an adult. I'll tell you that.
That's
Did he
true.
get?
But I
I'm
paid
sorry?
for it. I said, that's true. I went to prison. I went to prison for it and everything. I paid
Not
for my.
shocked. The system would be a complete failure if you hadn't. Wait 1 second. Let me double check something here. There's printed on June the 8th. I see. We got the offense date wrong on the CCH. It should be February 5th. Okay. You live on Adams Street, Monroe?
Yes.
What kind of bonds conditions did I set? Did I set bond conditions on this, Heather? I should have.
I'm going to look right now, Judge.
Here they are. I was gonna say, I didn't think I'd get that flustered by somebody screaming at me. I got it. All right. Where does he work at?
Your Honor, he is disabled. He has PTSD, and he has not worked in several years.
Is he on disability?
Yes, he's on fixed income SSI disability.
And he lives on Adams?
Yes, Your Honor.
Who do you live with on Adams?
I live by myself. My mom lives above me and I take care of her because she's dying right now. I live at 311 Adams and she lives at 311 and a half Adams right above me in an apartment building. And I pay my own rent and everything, so $725 a month.
What can you post here?
I'm sorry, I didn't hear you.
How much money can you post? I can lower the bond, but I'm not gonna give you a personal bond.
Okay, well then I'm not going to accept the plea.
I already took your.
I'm not going to accept the plea if you don't let me out. I mean, I just that's yeah. I'm not going to accept the plea then. Yeah, I just rebuke the plea and we'll just do the whole time, and then I'll just put you in civil court because I believe you took the.
You want to get belligerent with me, Mr. Williamson?
I'm not getting belligerent with you, sir. You're getting belligerent with me. I want to get out, and I
Well,
didn't do
good.
it.
I wanted to be the president. Some things don't work out. I'm telling you, don't
Well, then I
start getting
refused. I
crappy with
refused.
me. You
Okay,
got
then
it?
I refused.
I'm
Then
looking
I
for a
refused.
way to pull you, get you out of there, but you're not going to
I don't have
negotiate.
any money for bond. I don't have any money for bond, Your Honor. That's all it is. That's the only
We
problem.
can set it for a jury trial in another month if you want. I can do
That's
that
fine.
for you to
That's
keep the
fine.
bond in effect.
That'll be fine. We'll go for a jury trial in a month then. All right. Because you took a blood test from me on the 8th and you arrested me on the 5th.
I didn't
So I really-
arrest anybody. I'm not a police officer.
Look, I just want to get out and go to my mom.
I don't care what you want. I'm going to tell you right now. I don't care what you want. There was a reason I set this bond, and it wasn't just because you got belligerent with me. I'm trying to figure out a way to release you, but I am not giving you a personal bond. You don't deserve a personal bond. You hadn't shown up on the case. You got a prior, and you got multiple felony charges and convictions. So please, don't act like an angel with me.
All right. I refuse to plea then. We'll go to jury.
You want to talk to him?
I do, Your Honor, if I.
We'll put you back in a breakout room. I was looking to reduce the bond. I'm not giving him a personal bond.
Your Honor, do you have a?
I'm not gonna negotiate with
Three weeks
anybody
is still
here.
already though. Does that
Mr.
matter?
Williamson, I'm talking to your lawyer right now. You are
Okay.
not helping yourself.
Sorry about that.
You don't want to get out. You wanted to get out. Well, maybe you should have thought about that before you started swearing at me.
I didn't mean to swear at you. I apologize. I didn't even know he was in court. My screen was messed up. I'm being honest with you.
Your Honor, if I could have 5 minutes, that's all.
We'll send you in a breakout
All right,
room,
thank you.
okay? And as of now, I have accepted his plea.
I understand that.
Okay? All right, stay seated. All right, we're back on record on Williamson. Let's go back on that. Be calling Robert Eugene Williamson, 26F245-827A and B.
Good morning, Your Honor. Peter Renaud, P78443, MIDC counsel. Your Honor, I tried.
Sir, your name again? You have to unmute. State your name. You have to unmute and state your name.
All right. Robert Eugene Williamson III.
Okay, go ahead.
Unfortunately, there's been a breakdown in the attorney-client relationship. I was not able to get through to Mr. Williamson about some of the points of law regarding his case, and at some point he said that he would prefer to represent himself going forward. So I would ask the court to withdraw.
I want you to know, Mr. Williamson, there's no basis in law to plead guilty to something. And that before we go on, just relax. Just relax. Listen to what I'm going to tell you so you don't hurt yourself further. There's no basis in law to tender a guilty plea. Ask your lawyer to file a motion or orally argue a motion to reduce the bond. Have the judge deny it and then say you want to withdraw your plea. That's just not how the system's going to work. Now, I'll be glad to let you file a motion to withdraw your plea if you choose to represent yourself. I'd strongly advise you against discharging Mr. Granada. Sometimes lawyers are a little bit like doctors. They have to tell people, clients, or in doctors' cases, patients, things that they don't want to hear. But see, you don't have any schooling in this. You're making a big mistake if you choose to discharge him.
I don't want to discharge.
You, just listen to what I'm going to tell you. I was reminded as to how vile your conduct was on the break. That being said, I'm talking about the arraignment. That being said, I'm going to overlook that. I'm going to be a lot more fair with you than you have with the system, not with me. Not with me. I don't know why you're so angry with the system. There's no basis for you to be angry with the system. If you were convicted of all these felonies, well, then you committed them, period, plain simple. So if you want to discharge Mr. Granada, you want to have that conversation, that's fine. You can move.
I don't want to discharge Mr. Granada.
Your Honor,
I just can't afford bond. That's all.
Mr. Williamson, it's a different conversation. That's a different conversation. You don't get to decide what the bond is. You should have thought about that when you were throwing around F-bombs at the time of the arraignment and when you didn't show up on this case and when you accumulated a record.
Well, I would like to go to trial. Is that okay?
Unfortunately, I have accepted your guilty plea already. And now you're going to have to find a legal basis to ask me to set aside the plea.
Okay,
and I'll be happy to entertain that.
I can do that now. The legal basis is that he told me that I would get time served today if I accepted the plea. And that's not the case.
Hang on a second.
Your Honor, I explained that because it was a drug-related case, that he had to report to probation. And that this wasn't over until after that interview had taken place and at the sentencing hearing.
Mr. Granada has been around. I don't believe he would tell you that. Okay? He didn't tell you were getting time served because he knows, and I know, and anybody who's been out of law school for a day knows, I have to, by law, order a screening and assessment on a drug or drunk driving. It's not my rules. You can argue with this legislature if you want to. So he would never have told you that.
I did explain to Mr. Williamson.
Well, it should be on video. If you look at the video, you see I'm telling the truth.
Mr. Williamson,
I did explain to Mr. Williamson that in your discretion that you would be able to
reduce the bond if I wanted to.
Well, that you would be when it came to the penalty phase.
Of course I could.
That you could give him.
Of course I will. It's not discretion. Of course I will give him credit for every day served. Doesn't mean that's going to be the extent of the sentence. It doesn't mean it won't be the extent of the sentence. So I'm trying to tell you here, I and by the way, I was trying to help you. I
Okay,
was not, even though you acted like a child who has an anger problem when you were at the arraignment in Flat Rock. I was reminded by my staff. And I mean, you ought to be embarrassed for yourself. But even though that occurred, I'm still going to be fair with you. But I'm not going to bend over and let you change the rules or dictate to me or dictate to the system how the system's going to handle the case. It's not happening. Now,
okay,
I accepted your plea.
okay,
Period.
okay,
I'm going to order a screening and assessment.
okay,
Probation's going to come in here and interview. I will give you an early sentencing date when Mr. Granada is here. If you choose to move to withdraw the plea in the meantime, I will be happy to entertain that, but you're going to have to do it in writing through your lawyer. If you want me to discharge Mr. Granada and you want to draft the pleading, which I would find to be a complete impossibility for you to do on your own, I'll entertain that motion verbally right now. He told me he wanted to withdraw. He thought there was a breakdown. You said you don't want him to withdraw. Do you or don't you want him to withdraw?
no, I don't.
Okay. So I will give you an early sentencing date.
Okay,
I will, on my own accord, reduce the bond, not from a 40,000, 10% to a personal. I will reduce it, whether he can post it or not, to 10,000, 10% post, 10,000, 10% bond. So if you can come up with $1,000, you will be released. Otherwise, you'll appear for a sentencing date, and we're going to do it soon. So
okay,
I will be a lot more fair with you than you have been with the system. You're good with that, right?
I'm good with that.
Because if I wasn't going to be more fair with you than you have been with the sentencing, I'd keep the bond in effect and I'd set your sentencing for the end of August. I'm not going to do that, no matter how belligerent or no matter how belligerent you are or some other defendants that hate the country are. Okay. And if you're
Okay,
threatening to sue and all this stuff, feel free.
thank you.
Feel free. Give me an early sentencing date. The
Thank you
earliest
for your
you can get.
generosity.
Okay, Judge. So
Let's do
it doesn't need to be on a Flat Rock day, correct?
No, there was no accident here. I could do this early next week.
Is
Mr.
Mr.
Granada's
Granada
available.
here on Thursday, on the 2nd?
What's that?
Mr. Granada, are you here on July 2nd?
Why don't we try to move it to Tuesday or
yeah.
Wednesday?
Oh, Tuesday, okay. I don't think we have Mr. Granada here though, do we?
Let me check. I'm looking at my calendar right now.
I'm looking at the calendar too, July. I don't
Okay.
have you Tuesday. I don't
Even
have
if
you
you-
on Tuesday or Monday. The soonest I'm seeing you on the calendar is Thursday, the 2nd.
Yeah, that's what I'm showing. Thursday the 2nd is my next time before the. I do have.
You have subsidiary?
I think coming on the 29th or the 3rd.
Can you do it the 30th by Zoom? Can we get in trouble with MIDC by having him do that one
Only if
case?
there's no overlap. I'm in 34th from 8 to 11. So if we could do it after 11, then I'm good.
I don't have a problem with that. Can you be here by 11:30, do you think, or not?
From Romulus?
Or do you want to do it at 1?
Can we do it at 1?
At 1 o'clock, June 30th is when I'll send you. You're going to wait and probation's going to come and talk to you. If you somehow post your $1,000, you'll be released. And anyway, your sentencing will be Tuesday at 1 o'clock. Good luck. Bonds
Thank you.
continue. Thank you. What's your name?
Nathaniel is,
What are you here for?
Prosecutor review out of Trenton. I told him about the Trenton prosecutor, haven't got filed yet.
Okay.
just said anybody, I've been waiting out there since 8:30.
You checked in with the Trenton prosecutor like I told you a little
I
bit.
wrote on the thing, I knocked on the door a couple times.
Jesus.
Sitting there waiting the whole time.
Wait a minute. Where is the Trenton prosecutor, John?
Yeah, it seemed
They
like.
said he was here at the front desk, outside.
Take him over to 236, the conference room 1, will you please? We'll take a recess. It'll take you right to the prosecutor. Everybody stay seated. All right. People against? Nathaniel David Hayes? Oh, geez. It's just non-compliant. Your name?
Nathaniel Hayes.
Yeah, I adjourned this because you had an operating while impaired and it says you were convicted. I'll give you a lawyer, but I cannot dismiss this case. You didn't comply. The most important thing was not to violate a law. I took it under section 771.1. Want a lawyer? I'll give you a lawyer. But I'm not dismissing a case if somebody's convicted of operating while impaired. Do you want a lawyer? I'll be glad to give you one.
Sure. The last time I was here, Your Honor, you postponed it until today to see what the judge there in Wyandotte would say. She dropped it down to operating while visual.
You were convicted of operating while impaired. I cannot possibly dismiss this case. You're not compliant. Colin Trenton, what happened on this, Mr. Hayes? Was the prosecutor, what happened? Did you knock on the door?
Yeah, I knocked on the door twice. I even asked the people at the counter if he was even here. They said yes. He said the wheels were just like this slow. So
I didn't even have a docket with him today, did I? Was he with?
No, the judge has.
Let me call him. I'll give you a lawyer. The original charge here was illegal transportation of a firearm. And so I just cannot dismiss it if you're convicted of operating impaired. You want me to give you a lawyer?
The prosecutor's coming.
Well, you should. Wait a minute. Don't tell me under your breath you don't know what's going on. I told you what was going on. I told you I was adjourning the case pending the outcome of the Wyandotte case. Now, if you want to act sanctimonious like you got out of that because you were only convicted of impaired as opposed to OWI, I'm sorry. That's not true. Your name?
Anthony Bloody.
He was convicted of operating while visibly impaired. So I cannot dismiss this case.
Which one is this, Your Honor?
Nathaniel Hayes. But the bigger issue is he said he was knocking on the door. I want to make sure we're doing what we need to do in here internally. Was his name on there?
I don't know if his name and that you're not the door.
Did he sign in the sign-up sheet? What time?
he told me to.
What time?
Check that early this morning.
What was that did you have a big docket in front of you?
It's still going here.
Okay. Well, I'll give you a lawyer. I'll enter a conviction. I'll give you a lawyer for sentencing if you want, and we'll go from there. But I cannot in good conscience, when somebody's convicted of operating while impaired, dismiss under 771 on the basis that they were compliant of the terms of probation. So I'll tell you what I'm going to do. And there's nothing to worry about here. I can't imagine me sending you to jail or anything like that. But I want to get you a lawyer. It's getting later in the morning, and I'll set this on my next Trenton date. Lisa or Heather, just give him a date when he comes down there and make sure he's got a lawyer ready for him. Okay.
Okay, Judge.
Thank you. You can go down the hall to give you a paper notice. Good luck.
Court calls case of the people versus Andra Hunter.
Good morning, Your Honor. Again, Trovius on behalf of Mr. Hunter Jr. Mr. Hunter Jr., state your name.
Andra Hunter.
Your Honor, my client is urging me to set this matter for an exam. Discovery is not complete. I should be okay, but discovery is not complete.
What's missing?
Well, I was just appointed to this case yesterday, and I made the discovery request, and I've informed.
You don't have any.
I don't have anything. I've informed my client that the best way possible is to adjourn it so I can get the discovery.
Who had the case before?
The PD's office. They did send me something, but I just got this case yesterday late afternoon. But again, my client is urging to set this matter for an exam.
Is that correct, sir? Yes. Understanding that your attorney may not be ready.
Yes.
And when appropriate, Mr. Hunter would like me to address bond as well.
I'm going to mark in the file that there'll be no adjournments for any discovery issues. That's going to be on you guys. People have their witnesses available the 7th or the 14th. We're going to have to go to
14th would be great. Thank you.
preliminary examination in person, July 14th, 2026, 9 a.m. before Judge Washington.
Your Honor, I believe Mr. Hunter's bond right now is no bond. Mr. Hunter, he's 33 years old. He has a total of 4 children. His family is in the courtroom. He resides with his children, his girlfriend, himself, of course. He works for construction with his uncle. I believe he has a violation of probation case. Yeah, I know he has a violation of probation, I believe related to this, but I'm not sure. And I was just appointed to that one. That's up on July 7th in front of Judge Conkey at the circuit court. We were asked that.
Where do you get no bond?
That's what my client told me.
Well, he's obviously not telling you the truth.
But what is his bond, Your Honor?
It's 1,000 cash surety.
I'm sorry, say that again?
1,000 cash surety.
Tell me, I already paid 1,010%. $10 and I was supposed to get a tether.
Oh, okay. Your Honor, I would ask if the bond can be amended to a 10%, $1,000, 10% along with the tether.
Any response on these charges? Any response from the people?
I didn't even say anything about self-defense.
Over here for Miss Fulton's in.
Application.
Say the Fulton's in. I'm sorry.
It already is.
1 out of 10.
I don't know why you're wasting my time. His bond is already 1,010%.
Told me I was.
Motion for bond reduction is denied. I don't even know why we had to hear that. Thank you. We're done.
Heard it from me. It's $1,000, 10%.
For a cause of case, people versus Benlea Winter.
Are you reading for people? Oh, defender on behalf of Benlea Winter.
Oh, I'm sorry. Miss Winter is approaching.
Your name?
Correct.
Benlea Winter.
All right. Just competency hearing. I have the competency report. Is there anything additional from the parties?
No, Your Honor, if you would stipulate to the report.
Mr. Getty,
Yes, Your Honor, we would.
all right. I would stipulate that the report indicates that the defendant is competent to stand trial. Court would indicate that upon review of the report, the defendant can understand the nature and objects of the proceedings against her and can rationally assist in her defense. Therefore, the defendant is deemed competent, and I've signed that order. What would you like me to set this for?
We'd ask for
Set a probable cause conference for July. Is this the only case holding her? No, you got something.
I have a PR on the other one. Sorry.
There's a PR on your other case?
Sure.
Well, there's a.
Your Honor, I'm seeing look like there's 2 out of 1. There's one thing, one function else fine. The girl one's just a traffic offense, but the Novi one is drug related.
I reached out to Novi. I sent them a letter. And
Pardon?
I reached out to Novi personally. I sent them a letter. And they just sent me back a letter by itself. I plan on going, if I get released, to handle that.
And as far as the county, Your Honor, we've seen that there is the 14B, like concept.
Out of 14B.
That's what actually.
Well, what I'll do is I'll adjourn this to the 9th, 2025, or 2026, I'm sorry, 9 a.m. I will. You have 25,000 cash surety because there was. It usually indicates to me that there's.
Looks like there was a bench warrant in this case, Your Honor.
Yes, and I'm not. Oh, that's why.
I was seeing psychiatric help during the time, I think, around of this. I completely forgot about this incident.
Okay, hold on a second. Okay. I don't need you to go into detail, but where are you with your mental health treatment?
Honestly, I didn't get the correct mental health services until I came here. I was involuntarily withheld a couple of times at Havenwick Hospital, and they gave me meds that weren't working. Here, I was able to work with a psychiatrist to find medications that help, and I've been on medication, yes, since March.
Since March.
Yes,
Okay, and you're continuing on those medications now?
absolutely.
Okay, hold on a second. That was in March of this year?
Yes.
Anything else regarding this defendant's bond?
Yes, Your Honor. Ms. Whitner.
So if you're ahead, you're gonna talk?
What?
Go ahead.
Sorry, Your Honor.
Thank you.
I'm sorry.
No, we're waiting.
She does have people in the community. She has a brother and a sister who live in Ypsilanti. But as can't continue with CMH as reported, she's working with the reentry program. There is a pharmacy that's already been identified on Michigan Avenue that can fill her prescriptions. And they've made arrangements for her meds to go there.
I could have issued this like an hour ago, but it's okay. Go ahead. I'm listening.
Nothing further.
Thank you. Motion for bond reduction is granted. I'll set your bond at a personal recognizance. $25,000 bond. Just make sure you show back up. You hear me?
Sure.
All right. Thank you.
I don't win often, Your Honor.
No, it was a brilliant argument. Court does call the case People versus Tyrese Pitts.
Morning, Your Honor. Raymond Cook for the panel.
I'm sorry, Your Honor. Attorney Sharon Jones, P number 57113 on behalf of Mr. Pitts, who is in the jail approaching. And Mr. Pitts, if you could please say your name.
Tyrese Pitts.
Your Honor.
All right. Yes.
Thank you. Today is the date and time for the PCC and also for hearing on a bond motion I filed that is regarding a funeral. We are asking to set this matter for exam.
Is discovery complete?
It is, Your Honor. It appears to be complete.
People have their witnesses available the 7th?
Yes, Your Honor. We'll do about.
All right. Preliminary examination will be set July 7th, 2026, 9 a.m. before Judge Fresh Hour.
Your Honor, if I may, the co-defendant's case was also set for exam that day before Judge Perry. Would it be possible to keep these two cases together? It would be the same.
Oh, yes.
Thank you.
We'll do that. So the co-defendant's already been sent before Perry.
That's correct, Your Honor.
All right. So we'll make this before Judge Perry. And then Esteban, did you?
Your Honor,
Go ahead.
a family member died and the funeral.
Yes, go ahead.
I believe my client's family member's funeral is tomorrow. So he is asking that he may be allowed to attend his loved one's funeral and say his last goodbyes.
I don't. Any response from the people? I don't know. Did you get a copy of this motion?
I do not have a copy of, there was a written motion filed. I do not have a copy of that. I'm checking because I saw on the docket, it looks like it was a motion set. I did not see one in our file nor in my court, so I was unaware of what exactly the motion was. Regardless, I would be objecting to any change or release at this time. This is a case where defendant, along with a number of other individuals, were fleeing from police and what I believe ended up being a stolen vehicle after a shooting out of county that 120 miles an hour on the highway past them on the right, going through the red lights. When police eventually found the defendant after they fled on foot from that vehicle, he was hiding in an apartment. I would also note that this defendant has numerous prior convictions that give me reason to believe that he is a danger to the community. I'm seeing as far back as 2016, I believe. There's a felonious assault. I have convictions for, excuse me. Scroll down under. CCW, receiving, concealing a motor vehicle, malicious destruction of police and private property. 2023, felon possession of a firearm. 5, it looks like. There's another conviction, or sorry, no, those were just found over. I don't know what the disposition of those charges are, so I'll leave those off. At 2026, the defendant has a fleeing and eluding in 3rd degree, as well as a recent CCW conviction. So I have concerns that this defendant proves to be a flight risk as well as a danger to the community. I sympathize with the defendant of the loss of a loved one, if I don't believe that release is appropriate at this time.
Your Honor, and my client currently is not facing any type of charges alleging that he fled from police. My understanding is that the arrest was in an apartment building or apartment complex.
After they got out of the car and ran to it, and the police followed them there. I realized they may not have charged that, but
well, Your Honor, all I can say regarding the charges is that my client disputes that, but this is his last chance to say goodbye to his brother. And it would seem to me that if he could have some sort of escorted opportunity to attend the funeral, that.
And Your Honor, just for some additional context, as far as the firearms involved in this case, pursuant to a search warrant, police received a box of Hornby .40 caliber ammunition, an AR-15 magazine, an AK firearm with a double magazine, an AR-15 rifle with a magazine and shell catcher, an AK hell pup with a magazine, a Glock 17, a .40 caliber Glock magazine, a 9mm Glock magazine, and a Glock 22 handgun.
all right. I'm not going to let this. I understand and I feel for the defendant, but I'm not going to allow release at this time. His bond will continue. Thank you.
Okay.
So
Thank you. I'd also filed a motion for a team member to go interview Mr. Pitts at the jail.
For who?
An investigator. I think I submitted a proposed order just for them to be able to visit him at the jail to do an interview to assist me because of the volume of discovery.
I don't have a copy of that motion either, so I'm not able to.
So I don't, counsel, I'm not, you got to send a copy of your motion to the prosecutor's office, because this is now the second one that they don't have for whatever the reason.
They're in the email. I sent it to your court and to the prosecutor's office. Both.
She did what?
The prosecutor's office.
So you sent it to the generic email for the prosecutor's office, didn't get a name?
I sent it to the only email I had for their office.
Okay, well, I'm not going to address, if they don't have a copy, I'm not going to address it because that puts them behind the 8 ball because they don't have the information. But so I'm not going to address that motion. All right, thank you.
Thank you, Your Honor. May I may I ask, do I just send it to the prosecutor that just spoke? Is that the correct individual at this point, or would it be a different prosecutor since it's before Judge Perry now?
Ma'am, you can send it to me and I can give you my email. Once we're off the record, I can shoot you an email because I believe I have your email.
Okay, thank you. I would appreciate that.
Thank you.
Feduro? Miss Feduro, which case are you here on? You're muted.
Nico Harrell. Nico Harrell versus State of Michigan. Well, the State of Michigan, sorry.
I got you.
I'm a victim.
Spell the last name for me.
Harrell.
Harrell. Okay, he's a show cause. I don't know that he's here, so we'll just label you accordingly and keep you where you're at for a while.
Okay, I would like to speak if given the chance.
Yeah, we can do that.
Okay, thank you.
All right, ma'am, go ahead and put your name on the record. Reference Nico Harrell.
My name is Taylor Fredero.
All right, and I'm confused as to why you're here.
Okay, I am the victim in this case.
Which case? Because I've got a number of files on him. And I don't have any assaultive crimes.
Then I don't know why I received a victim advocate letter.
Oh, you know what? I think I got you wrong. I got the wrong stack of files. Harrell is the guy you're here for?
Yes.
H?
Yes. Correct.
And I don't have a file. Is he on the docket today?
Yes, he has the whole staff.
I got a Waddell.
Wardell,
no,
Nico
hold on.
Wardell.
I got
Wardell
one
is his
Harrell
middle
file.
name, sir.
You should have a white one.
No.
If you didn't. Oops, got it wrong.
No. All right, I don't have that file, ma'am. I got like 7 other files. 1, 2, 3, 4, 5, 6, 7, 8, 9. I got 4 misdemeanors and 5 civils. But go ahead and put your comments on the record, ma'am. He didn't show up today, so we'll be issuing a bench warrant.
Okay, so this would have been regarding him smacking me 3 years ago on our daughter's birthday. At a custody exchange this past Saturday, he held me hostage. He spit all over me in front of our daughter. I just don't want to have to deal with him anymore. I would like
Are
to
there
have no
charges
contact
pending on
order.
that?
I'm
Were
sorry,
the
what's
police
that?
involved Saturday?
I called the police twice and they did not answer. I don't know what happened.
Where did this
He
take
eventually
place?
let me leave
Where did this take place?
in Romulus, right in front of his house.
All right, then I would suggest you go to the Romulus Police Department and make a report.
Okay.
All right. So your comments are on the record. As I said, there'll be a bench warrant issued for his arrest because he didn't show up today for the court date.
Okay.
All right, but
Okay.
definitely make a report.
Okay. Thank you so much.
Oh, hold on a minute.
4-0742.
Jamie,
Yes, sir.
can you see if Mr. Harrell's out in the hallway?
Harold?
Harrell, Harrell. First name Nico.
Not Tim.
I do have the actual case number that I'm involved in, Your Honor.
Oh,
if
we
you'd
got
like it.
that. It just
Okay.
didn't get pulled with all the other files. We got it in the system.
Okay.
Are you ready on Harrell? Harrell, I got a victim online. All right.
Just here for a show cause I'm work program. What is the victim about?
The problem on his domestic violence file.
Okay, there is nothing on the packet that mentions.
Okay.
He said find the file.
Okay, all right, so I got a victim online, there's an allocation, there's been a violation on, as of Saturday, this week. What was scheduled for today is the show cause on all of these.
So
He was given the chance to do community enrichment program to take care of some of his fines and costs because he's into us for over $4,000. April 13th, he failed to appear for the work program. April 20th, failed to appear for the work program. And so far, he's done 0 of 5. So he hasn't paid any money. He hasn't done any days that we gave him a chance to take care of the money that way.
good news is he's got a job.
Where? Aunt Millie's. The bakery? How many hours a week? When'd you get the job?
This will be my third grade.
Okay. All right. So why haven't you been able to do any work program?
Really originally trying to look for the job because I was working at a car wash. Well, my uncle car wash, but that was, you know what I'm saying? Then
How did that stop you from showing up for the scheduled work program?
the first day I was totally forgot. Even with that, and that's why I paid. I got child exploitation going on. You see that domestic violence case 3 years ago. Now that I'm trying to get custody of my child, now you're trying to bring this up, trying to do all this allegation and stuff. And then I'm like,
Okay, let's not talk about the domestic violence while we're talking about all this.
I can't make excuses. I'm not making excuses.
Yeah, I'm asking, he is working, but he gets days off, so I'm asking that the work program be.
I got my work. I got my work.
That work program be reinstated and that we set up a payment plan with the understanding if he doesn't pay on time, then he's looking at jail time. Can't just not pay, you have to tell him for it.
Especially when the court gives you the option to just do work program instead of $4,000. So I'm gonna send you back to Avery on these from community enrichment, see if you can start to make a dent in this. Have a seat until we get the domestic violence file up here, because I don't have the file yet. I just know this woman showed up today and I asked her why. So let me,
Appropriate for her to skip probation or something? Is he not on probation?
I don't know. Because, okay, nobody's asking you a question. You're better off not talking. So let me get my hands on the file and then we'll talk again. I might have to just schedule this on a Tuesday when the prosecutor's here. I don't know. All right.
He's supposed to be here at my phone, gonna show up. This,
Mr. Harrell. Yeah, so I've got his domestic violence file. I've also got a 9/22/24 Drobo license suspended and a May 26/23 Drobo license. He's never been sentenced because we can't get him to show up for court. So I can sentence on those two if he'll let me sentence on a Judge Martin DWLS.
Catch all that?
Yeah, I got the domestic. We'll get back to that. I've got a Drobo license suspended. He took a plea in front of Judge Martin. This file goes back to September 22/24 incident date. I can sentence him today if he's okay with me sentencing him instead of Judge Martin.
Oh,
Just to get it done.
yeah.
All right. Then we've got another file that's my file, and this one's from May 26/23, Drobo license, unlicensed or without cycle endorsement. He's never been sentenced on that. So we can sentence on those two today, and then we can talk about the domestic. All right. So are you working? Where are you working? Aunt Millie's, and that's a new job.
This is my third.
Yeah. Okay. What's the status of your license? You still suspended? All money issues? You're living right here on 4th Street? All right. What days are you working at Millie's?
Hard to see, so like this week I work Monday, I was off Tuesday, and I work Wednesday, and I was off Thursday, which is today. I go to work tomorrow. And I'm on Saturday, Sunday, next week I work.
How far in advance do you know your schedule? Do they do it once a month?
They do it for once a month.
All right. All right.
I think I got it so out for like Monday, walk Tuesday, Wednesday, yeah, I work Friday, Saturday, Sunday, Monday.
All right. So what I'll do on these two files is you're already into us for way too much money. So I'm just going to order 5 days on the work program on each of these files. Do you?
I'm very sorry to do this. Can you please give me those keys?
Oh, yeah, sure. 240742 and 24 RP 056 128B.
Thank you.
Oh, I'm sorry. Yeah. So scratch that one. I'll give you another one. 23 VB 01712A. So on each of those, you owe me 5 days on the work program. Do you?
10 days all good.
Correct, but no money on those two. Do you have your schedule far enough in advance so you can schedule those today, or do I need to give you some time to come back and schedule those? Like after you get your July schedule or something? So that doesn't give you enough time. So I'm gonna give you until. Are we open the 5th? We'll close the 5th, aren't we?
We're closed on the 3rd.
We'll close the 3rd, so we're here the 5th?
This Sunday.
Oh, I'm looking at Jim. Okay, yeah. So I'm assuming you'll have the next schedule by the 3rd of July, because this schedule's up the 2nd, right? So I'm gonna give you until the 10th to come in here and pick those 10 days. Or if you have to, pick 5 days in July, and then when you get your August schedule, come back and pick 5 more, or whatever you can do. Okay? You got that, Vanessa?
Top of office community management.
Right, you understand that? This is separate from the files I sent you down to talk to Avery about. So whatever you work out with Avery on that $4,000 you owe us, if he's giving you the option to do work program there, it's not these 10 days, it's different 10 days. You can't double dip. I'm giving you enough grace on these now. Understood? All right, so now what I've got is the domestic violence file from July 13, 2023. He's scheduled for sentencing in front of Judge Patton on July 7 at 9:45. So given the fact that the sentencing is just a little over a week away.
Not a sentence, I just gave you new.
Oh,
That's just. He's
not,
he doesn't here.
okay. All right.
So wait, is there?
So we can sentence on July 7th. Is that what?
We can have a pre-trial on July
Oh.
7th.
He hasn't been convicted.
He hasn't pled on it yet?
No, nothing.
Okay.
Okay.
He,
So we can give him a July 7th pretrial date.
July stuff. Okay. That is,
I already had it.
Tuesday.
You've had a lot of pretrial scheduled, but
I had it.
but the case hasn't been resolved. You haven't set it for trial, you haven't taken a plea, so we got to do it.
I guilty. Then the last one, it wasn't here, it was in another court, they switched it to this one. And the lawyer, I had pictures and everything.
You're getting something mixed up because the domestic violence never goes anywhere else.
You saw me pictures of her face and everything.
Yeah, but domestic violence doesn't get switched to another court.
It's happening in Belleville, it didn't happen.
Yeah, Belleville's venue is here. Belleville stuff happens, goes through here.
It was not gonna be in front of Judge Oak, right?
Currently, I can give him a Judge Patton date 7/7. That's the quickest date we can get. Yeah, but this case hasn't been handled yet. You might have been here before, but it's not resolved. So either it's got to be dismissed, there's got to be a trial date set, there's got to be a plea taken. Somehow we got to get it resolved.
Like last time when I came, and
What was it?
when I scheduled, it was this building, when I scheduled and I missed my work program, I was seeing on domestic violence, and that's when they showed me the pictures. I'm like,
Okay.
Okay, but that doesn't matter because the case hasn't been resolved. It's an open case. You got to deal with it.
Come back for a pre-trial. So that's gonna be the 7th.
The 7th. 9:45. No, we're not working around your work schedule anymore.
So it's on Zoom.
Can you get a break at work so you can Zoom?
oh, yeah, I got it.
Okay, it's 9:45, it's Zoom. All right. So Ms. Feduro, July 7, 9:45, the prosecutor's gonna want to hear from you on that day.
Okay.
All right?
Okay, thank you.
Thank you, Don. Okay, now you need to go downstairs.
Well, let's talk about bond.
Well, this was an arena?
No, he got arraigned back in June He's on a personal bond. I'm just gonna order no contact. So no contact with her.
What about our 11-year-old daughter that he's doing this in
Want
front
to
of?
have contact with him? Between now and July 7th, do you want to have contact with him?
I do not.
Can we arrange for the child to be exchanged through a third party, Your Honor?
Ms. Federo,
This
you
is
hear that?
happening in front of our daughter, Your Honor.
All I want to know is, do you want to have contact with him?
I do not.
Okay, can you arrange third-party pickup for your daughter? If
Sure.
he's supposed to have her this week and you can make that arrangement, who do you want to use for third party?
My sister,
Your sister's name is?
Gina Fredero.
You can do that?
What? With that, can you order that she don't contact me?
No, I can't because she's not under my thumb on a bond. I can suggest it.
Gina,
Don't contact him if you don't have to, Mr. Herdaro, and if you do contact him, it's only about your daughter. You're just buying trouble if you do.
I know that.
yeah, sure, go
All right, so I'm gonna continue the personal bond. I'm gonna order no contact other than third party for the child visitation.
Thank
Are we clear, Mr. Harrell? All right. Good luck. Thank you, Ms. Federo.
Thank you, Your Honor.
Okay.
Don't forget what I told you. If something happens Saturday, you gotta make a report.
Okay, I will.
This is file number 906359FC, People of the State of Michigan versus Robert Martin Wagner. I see that Mr. Wagner is here along with his attorney. Is it Ann Ronheim? Ahrenheim. Very well then. Ms. Ahrenheim is here. Mr. Kerner is here. He's our elected prosecutor. The Supreme Court has, or actually the parties have stipulated to a resentencing. Ms. Ahrenheim, would you and your client join me at the podium, please? Now, we are here today for that resentencing. And you are Mr. Wagner? If you could get you to switch so we can get Mr. Wagner right into that microphone. Thank you so much. Mr. Wagner, the best that you can, would you raise your right hand? Do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Thank you. You may put your hand down. Counsel, have you had a chance to review the updated pre-sentence case report?
We have, Your Honor.
All right. Are there any changes you'd like to see made to the body of that document?
We have none.
Thank you. Mr. Kerner, on behalf of the people, have you had a chance, Agent Twilliger is here as well, if I had any say. Good morning, Mr. Twilliger. Have you had a chance to review the pre-sentence case report, Mr. Kerner?
I have.
Any changes you'd like to see made to the body of that document?
None, Your Honor.
Thank you. Mr. Wagner, if you had a chance to review the pre-sentence case report, has your attorney made herself available to you to answer any questions you might have or address you?
Yes, sir.
I know I talk fast. You want to answer fast. We got to let me finish. Has she made herself available to you to answer any questions you might have or address any concerns you may have about anything that's contained within that document?
Yes, sir.
As you read through that document, did you find everything in it truthful and accurate?
Yes, sir.
All right, thank you. Mr. Kerner, do you have any victims that wish to address the court this morning?
I don't believe so.
Very well then, counsel, if you're up to allocution.
I have a couple comments I'd like to make and then turn it over to Mr. Wagner. If I may.
Yeah, I know how to do this, and I got a program. We'll get there, but this is your opportunity to allocute, and we'll hear from your client, most assuredly.
As Your Honor knows, we submitted a lengthy resentencing memo last week, so I'm not going to go into any detail, but I do want to just point out basically the bullet points. You're here, we're here for you to decide what term of years to impose. There's not a lot of wiggle room. The statutory range on the minimum is 25 to 40. We've asked in our memo for 35, as Mr. Wagner has been incarcerated for 35 years now. So that brings the whole range basically realistically 35 to 40, but we'd still like to say a few things in support of less than the maximum of 40. First of all, I do want to thank the prosecutor for stipulating and agreeing that a term of years is appropriate in this case. As we all know, 35 years ago, Mr. Wagner committed a very painful, terrible murder of Mrs. Sunday. In so doing, it really shattered the lives of two families that are both in the courtroom, of course. And from day one, he has expressed remorse and is going to do so again today openly in front of others as well. I want to say a couple of things about his record for the last 35 years that establish that his rehabilitation is real. There's no disagreement that the offense itself was senseless and that it was fueled by his drug and alcohol addiction that had originated really in adolescence. And I want to comment on the amazing, really outstanding progress he has made with that realm of his life, the challenge of addiction throughout these 35 years. As Your Honor knows, in the DOC, particularly if you're a lifer, there are a lot of impediments placed in front of you to get any kind of treatment for that condition, despite the fact it was recognized the moment he got to MDOC. They immediately recommended treatment for substance addiction. So it really, and also in the DOC, there's a tremendously sad accessibility of serious drugs. And I think that Mr. Wagner has really done a tremendous job in battling that, and he knows it's a lifelong battle. I'd refer the court to the long quotation we put in from his substance phase 2 report from the therapist, who has really pointed out all the tools he has to continue on this fight once he goes home. So I'll just refer you to the memo and the exhibits in support of that.
I've read that.
Okay. And finally, I would really just like to talk about his goals. I mean, he has some dreams, and he may speak to that. That's up to him. But the number one goal he has right now is to reunite with his family, take care of his own health, which is a challenge as well, and be a comfort, a mutual comfort within the family that's waiting to take him home. His parents are aging. They're in the courtroom. They've been delightful support despite really the shame that he brought on them 35 years ago. They're tremendous support, the whole family is. And I think he has a really good placement, and I think that he's ready to go home. And so I understand that the court has some leeway here, so we would just ask that the court consider imposing something less than the maximum in this case.
Thank you so much, Ms. Arunheim. Get it?
That's pretty close.
Yeah.
Arunheim.
Thank you so much. Mr. Kerner for the people.
Thank you, Your Honor. We did file a brief in this matter, and it is our position, and we would request that the court sentence this gentleman to the maximum term of years allowed by law. Thank you.
Thank you, Mr. Kerner. And Mr. Wagner, this is your opportunity to address the court. What would you like to say before it imposes its re-sentence?
Your Honor, I did all these years for a crime I committed a long time ago, and there's nothing I can say or do. There's nothing words, and I've cashed in for my family, and that's not even nothing compared to what I've caused the Sunday family over these years. And I don't know what I can do. There's nothing I can do. There's no words I can really say to make up for that. All I can ask is, throw myself upon your mercy and ask for maybe some leniency. If I could address the Sunday family, I would be more than willing to address them. It was senseless. I shouldn't have. It was a terrible thing that I did, and I can say I'm sorry 1,000 times, but that's not going to make up for what I did. And I would like to ask for forgiveness, but I don't know if I was in their position, if I could forgive me. These were my friends, and Mr. Sunday was my friend, and I was doing foolish stuff, albeit under the influence of drugs and alcohol. I was steered in the wrong direction, made a fatal mistake, and that's no excuse. I shouldn't have been doing that type of stuff in the first place. And there's just not the words that I can say, the amount of remorse that I have for the family, albeit the shame and embarrassment that I've cast on my own family. There's just, I just myself don't feel like there's the words to say that could repair that or to even make any kind of amends for that. But if there was, I sure would like to find them. And the only way I feel like now at this point in my life is, well, you know, I don't know if I got a lot of time left, you know, but if I do, if I could get out, I would like to at least try to make up some kind of something by serving and helping my family, community, state, try to better myself the best I can and help others if I can. Just, I'd like to at least help somebody. That's the only way I can think of to even minutely make up for my mistakes. And that's all I have to say.
Thank you, Mr. Sunday. The court is ready to, I'm sorry.
Mr. Wagner.
Oh, I'm sorry, Mr. Wagner. Yeah, that's right. Have you said everything you wanted to say, Mr. Wagner?
Yes, sir.
Okay. And the court is ready to impose its sentence. On September 29th of the year 1990, Mr. Wagner murdered Phyllis Sunday in Vernon, Michigan. He was 18 years old at that time. On March 15th of the year 1991, a jury of this court convicted defendant of felony murder, breaking and entering a building, and felony firearm. For the crime of felony murder, a prior judge of this court sentenced defendant to life in prison without the possibility of parole. At that time, that was a mandatory life sentence. But in 2012, the United States Supreme Court issued its opinion in Miller v. Alabama, holding that a mandatory sentence of life without parole is constitutional for juvenile offenders. We know Miller is retroactive pursuant to the 2016 case of Montgomery versus Louisiana. Since Montgomery, the Michigan Supreme Court has taken an active hand in shaping the law applicable to juvenile offenders. That includes extending the definition of juvenile to include individuals who were 18 or 19 years old at the time they committed a capital crime. In other words, although Mr. Wagner was considered a legal adult for almost every purpose recognized by our society, our justice system considers him to have been a juvenile at the time of the murder. That requires the court to conduct a resentencing at which it must consider the mitigating effect of the Miller factors along with the traditional goals of sentencing, also called the Snow factors. However, the court is not required to provide a specific articulation concerning each factor beyond what is necessary to facilitate appellate review. That said, and in the interest of removing any possibility for doubt, the court has considered all of the Miller factors and all of the Snow factors. The court has also considered the very detailed sentencing memorandum prepared by defense counsel and the exhibits coming in at slightly more than 300 pages combined. The court has also considered the filings by the prosecutor. The court has also reviewed its own file to familiarize itself with the trial stage proceedings along with the updated pre-sentence case report. There is some mitigating effect to your chronological age at the time of the offense. You were at late adolescent at the time of those offenses. That means that the mitigating effect is somewhat less than it would be if you were an early or mid-adolescent, but it's still mitigating. Typically, when we discuss the family and home environment for Miller purposes, we see childhoods marked by physical abuse, sexual assault, domestic violence, homelessness, things of that nature. Miller itself refers to them as, quote, horrific crime-producing settings, end quote. Those sorts of adverse childhood experiences can play a significant role in maturation, but are largely absent from your personal history, Mr. Wagner. That doesn't necessarily mean you had a perfect childhood. Your attorney certainly went to great lengths to depict your parents as lovingly, but largely absent. That may have played some part in your criminal conduct in that it meant you had a greater opportunity to commit this crime than a similarly situated defendant with more attentive parents. However, the court finds that your home life minimally mitigating, if at all. What's particularly compelling to this court is your recent prison record. The court's going to focus its attention only on the last 10 years. Not something of an arbitrary cutoff, but the best predictor of your behavior in immediate future is your behavior in the recent past. In 2020, you were found guilty of assault and battery for repeatedly shoving another inmate. Your attorney points out that there were no allegations of physical harm involved, but the court doesn't think that the absence of physical harm should be the standard by which it gauges rehabilitation. What we're talking about is a crime, although admittedly a misdemeanor, committed while incarcerated. That tells the court that after 29 years of imprisonment, you still consider violence as an acceptable method of resolving a dispute with your bunkmate or cellmate. That gives the court great pause. Then, in 2021, there's an incident described as, quote, sexual misconduct exposure, end quote. Your attorney characterizes this as an obnoxious act of flashing. The other name for it would be indecent exposure, and that's a crime under Michigan law. The court was unable to locate any record providing specifics of this event, so whether it would be punishable by 1 or 2 years of incarceration is unclear. In 2022, we have another instance of threatening behavior. Based on the report, that sounds like another assault. There are also multiple instances involving Spud juice or prison-made alcohol. The most recent of those was in March of 2025. Each one of those would be a 5-year felony in violation of MCL 800 TAC 281 sub 4. Then there are 4 findings of possession of stolen property since 2018, with the most recent being, again, in 2025. That's far from everything in the last 10 years, but those are just items that jump out to the court as being expressly criminal in nature, and there are 10 of them in the last 10 years. They do not persuade the court that you are or are ready to become a law-abiding member of society at this time. They do persuade the court that you are undeterred by the threat of sanctions or the oversight by the Michigan Department of Corrections. In light of that finding, this court resentences you to a minimum of 40 years in the Michigan Department of Corrections, not to exceed 60 years. Against that sentence, Mr. Wagner, you receive credit of 13,051 days. You have a right to appeal. Mr. Schmidt will be approaching you with your appellate rights. So I'd like you to do, sir, is initial the form acknowledging that you received the same. If you'd like court-appointed counsel to assist you with an appeal, you've got 42 days from today's date to make that request. Thank you all very much. This court stands in recess. Safe travels, Michigan Department of Corrections.
Both involving State of Kansas versus JD Comstock. Greenwood County case number 2025 CR 150. Also Elk County case 2022 CR 51. Jill Gillette appears as county attorney for both Greenwood and Elk counties. Joseph Favre appears as defense counsel on both cases. Defendant Comstock appears by Zoom from the Greenwood County Jail Zoom location. These matters come before the court at this time for sentencing. According to the journal entries from the plea hearings in the case, the defendant appeared before the court on April 24, 2026 in Greenwood 25 CR 150. He entered a guilty plea to count 1, interference with law enforcement, a level 9 person felony. Count 3, unlawful possession of a controlled substance marijuana, a class B misdemeanor, and a guilty plea to count 5, criminal possession of a firearm, a level 8 non-person felony. The Elk County journal entry reflects that on April 24, Mr. Comstock entered a plea of guilty to an amended count 1, attempted aggravated assault, a level 8 person felony, and amended count 2, flee and elude, a class B non-person misdemeanor. Pre-sentence reports were ordered following the entry of those pleas, and sentencing was set for today. Court has received completed pre-sentence investigation reports compiled by Christine Donovan, pre-sentence investigator, who is present on this meeting with us. I trust each attorney has received a copy of these reports, and I'll ask the state's attorney first. Is there any objection to the criminal history that is stated in either one of these pre-sentence reports?
No objection from the state.
No objection.
Okay, go ahead.
No objection, Judge.
Very well. Court finds there's no objection to criminal history. Therefore, in the Elk County case, the criminal history score applicable to today's sentencing on the primary crime is criminal history score B. In the Greenwood County case,
The criminal history score applicable to the primary crime in that case is criminal history score A, and the court will proceed further accordingly. Ms. Gillette, do you know of any legal reason why sentence should not be pronounced in the Comstock cases here this afternoon?
I do not.
Mr. Favre, are you aware of any such legal reason?
I'm not, Judge.
Mr. Comstock, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing here this afternoon?
No, sir, Your Honor.
Court proceed further then. Mr. Favre, are you pursuing a departure motion as to one or both cases?
We are not, Judge. Pursuant to the agreement that we made with the state, we are not pursuing any plea agreement. Mr. Comstock is agreeing to do his time in DOC, and the state has agreed to not recommend these cases run consecutive to his other cases.
Very well. Are there any victims or members of a victim's family present who desires to address the court in relation to either one of these sentencings? Court finds no such persons present. So at this time, I'll ask for recommendations from counsel regarding an appropriate sentence for Mr. Comstock, beginning with Jill Gillette on behalf of the state of Kansas.
Your Honor, do you have a particular case you want me to start with? And do you want to do all of Greenwood and then all of Elk, or just both of them together?
Let's start with the older case first, but then go ahead and make your recommendations as to both cases.
Okay. So for Elk County 2022 CR 51, he did, as you said, score out for a B. His top charge on that is aggravated assault on a law enforcement officer. That was one of the deputies. He is presumptive prison, and in that case, we are recommending the standard box of 19 months. He has up to 20% good time credit. There is a special rule. He was on conditional release from somewhere else, I believe in Arkansas. There is a post-release supervision duration of 12 months and probation duration of 18 months. On the second count of conviction, which was count 2, is fleeing or attempting to elude a law enforcement officer. It does score out as a Class B misdemeanor. We would ask for 6 months underlying concurrent to the primary count, which was count 1. He has in Elk County scored out to be presumptive prison. As Mr. Favre announced, we did expect that he would be doing his time in KDOC. The helmet and gear that was with the motorcycle were returned to the victim in the Elk County case. There's $193 court cost. I believe he has his data on file from the Butler County case. Most of his history is from a prior state, so I believe he had to pay that over there. I am not recommending a fine because he is going to KDOC. I would ask the court to determine, pursuant to Robinson, any bids, application, or attorney's fees. He does have a $45 booking fingerprint fee, and that makes his total $238. In this case, as we were talking, the Butler, Greenwood, Elk, and Chautauqua County cases all happened in one giant chase that lasted 2 days. I'm not asking for them to be consecutive to any of the Kansas cases. He does have 3 Arkansas cases that these may be ran consecutive to, but I'm not asking for anything in the Greenwood County, Elk County, Butler, or Chautauqua. So that is the Elk County recommendations. In the Greenwood County case, the top charge is the criminal possession of a weapon by the felon, and that was count number 5 of the original complaint with a criminal history score of A. We would be requesting the standard term of 21 months. That would be his top number out of the 2 cases. up to 20% good time credit. I think I've kind of covered the other cases with the special rule that applies, and 12 months post-release supervision. The second count of conviction is actually count 1, interference with law enforcement, a level 9. We would ask that he have the standard box of 6 months concurrent to count 1 and up to 20% good time credit. It does have a post-release supervision of 12 months. The third count of conviction is count 3, and that's the possession of marijuana. It's a Class B. We would ask for 6 months there and run it concurrent to the top count. He would have cost in this matter as well. The $193 court cost. His DNA is being provided to Chautauqua and Butler County, I believe, previously. He does have a $45 booking or fingerprint fee. We'd ask the court to make determinations pursuant to Robinson to his bids and application fee and attorney's fees. Total before those is $238. I am not asking for a fine due to him going to prison. And again, I'm not asking for it to be consecutive to any of the Kansas cases that were all racked up at the same time. But there are the 3 Arkansas cases. So those are my recommendations at this time, Your Honor.
Moment, Mr. Favre. Favre, your recommendations regarding appropriate sentences in these 2 cases?
Judge, we do join in all the recommendations listed by the state as far as time goes. We would note the plea agreement considered in part because Mr. Comstock had been in custody for a very lengthy amount of time prior to coming before the court in Greenwood and Elk. He had been sitting in Butler County on the Butler County case that he was given 31 months on. He's still looking at a sentence that extends him into 2028. Currently, he was given a 31-month sentence in Butler County, which was the aggravated number in that county. He has taken early responsibility for both these cases. The idea would be that most of his time could be covered by his sentence that he's already done, since these happened before the Butler County case, and also because he's going to have a huge jump in criminal history, which he has had a jump up to A box now. So Mr. Comstock has complied. He's agreed to not file the departure, and you would ask the court to consider granting the recommendations made by the state and by his counsel, which are joint, and impose the sentences as recommended and allow them to run concurrent as allowable by law. Of course, he's going to have to go back to Arkansas. And I guess I'll just tell you, like, he's not from Kansas. He's originally from Arkansas, and he's got history between here and Arkansas and Missouri. So this event, this cumulative event that Ms. Gillette's discussing that happened between these 4 counties, and I don't know what's going to happen in Chautauqua, but for the Greenwood, Butler, and Elk County, they all occurred, as she said, in one basic string of events that kind of, anyway. So we'd ask the court to consider granting the recommendations and sending Mr. Comstock to the Department of Corrections for the time recommended by Ms. Gillette.
Mr. Favre, you said that he spent a very considerable amount of time in jail waiting for these cases to be resolved, yet the face sheet of the pre-sentence report only reflects 128 days of jail time credit. Are you suggesting that he served more time than 28 days?
No, Judge. I'm saying that prior to his entering these plea agreements, he had already spent a significant amount of time in custody. He's not been free of custody for the last about year. He's been between the Butler cases, between resolving the Butler cases and this case, he hasn't been out of custody. And in fact, he reminded me that prior to that, he was doing parole time in Arkansas, and he was sent over here from Arkansas. So how long has it been since you've been out of custody, Mr. Comstock?
I haven't been out of custody since these incidents occurred, Your Honor. I was locked up out of the hospital when I went to Missouri, and I was put back in prison in Arkansas for the last 3 years. And I've spent the last year, I paroled there, and I've spent the last year in custody here in Kansas, waiting to get all this took care of.
Yeah, so that was my understanding was he was in parole custody. He was in custody in Arkansas for the last 3 years, then came here to Kansas right after that to fulfill these holds. And he's been in custody with Butler County. He had 209 days of jail credit at the time of his Butler County sentencing in February. And then from there, he went immediately to Greenwood, where he's been serving time in Greenwood County custody. So he's been in custody continuously for quite a long time. And he still has a good year and a half or more, 2 years to go, depending on how his good time shakes out.
All right. Ms. Donovan, I trust that you started his jail time credit in the Greenwood County case as of February the 18th of 2026. Is that when he was sentenced in Butler?
Your Honor, I started his jail credit in the Greenwood case on the date he was booked on this case. And I will tell you, this time would have overlapped with the other matter that he's already been sentenced on, the 2025 CR 156 case. However, I was looking for the journal entry of judgment in that case, and I couldn't find the jail credit that was awarded for that case. So I do not know those dates. And I will mention, I did not include the Elk County time on the PSI jail credit. I do want you to know, I do know those dates, and should the court determine that he's entitled to jail credit on that case, I can provide those.
Well, you show 0 jail time credit days on the Elk County pre-sentence report, stemming way back to 2022. So did he have some jail time credit there that isn't accounted for here?
Your Honor, with all the changes in the jail credit, the law regarding jail credit, since that time, I will leave it to the court's discretion as to whether he's entitled to credit on that case. There was 77 days. He was booked into the Greenwood County Jail on the Elk County case. He never has been in custody in Elk County. And he was booked in on April 9th of 2026 on the Elk County case up until today, the date of sentencing, which would equal 77 days.
But this is already accounted for on the Greenwood County pre-sentence report, is it not, that very same time?
Yes, again, those dates overlap as well.
Okay. So he was arrested way back in 2022 for the Elk County case, at least, and he had no jail time credit days for the time after his initial arrest?
Your Honor, the Elk County case was not filed until recently. And that's why when he was in
Elk
DOC,
County's
they
case
placed a hold on him.
has a 2022 case number.
I don't think it was served, Your Honor.
His warrant was served when he came to Kansas and when he came to Greenwood County in April. So the warrant had been outstanding while he was in custody in Arkansas.
All right. Well, this was a concern I had before this hearing ever started, was the interplay of Butler County 2025 CR 156 and the effects that that case would have on this case. If this court isn't going to run the time consecutively to Butler 2025 CR 156, wouldn't he be entitled to all of the time that he served in Butler County too?
His arrest warrant for Butler, and he was brought to Butler County from Arkansas, was July 24th of 2025. But he wasn't booked into Greenwood and Elk until he was brought to Greenwood. So his Kansas booking was 7/24/25.
His journal entry for the Butler County case reflects that it was booked on 7/24. It reflects jail credit from 7/24/25 until the date of sentencing of February 18th of 26, which is 209 days. And I don't know, my interpretation of the law as I understand it now is that anything in that pre-Irvin period he would be getting credit for. So I guess we would need to know when he was served on the Elk and Greenwood cases to see if that time was creditable as well. When was he served with those warrants?
He was brought to Greenwood February 18th of 26, and he was served with the Elk warrant in April. Well,
He was served with the Elk warrant in April of 26.
Yes.
And when was he served with the Greenwood warrant?
2/18/26.
So they had to have had a hold on him before then because they brought him straight from Butler to Greenwood.
Correct.
So when did the Greenwood warrant attach to him so the Butler knew to hold him?
The Greenwood warrant issued. Hold on, I'm looking through all the different cases here. Just had it pulled up.
I show the Greenwood warrant was issued 8/21/25.
Counsel, Ms. Gillette first, any other reflections on jail time credit?
No, Your Honor.
Mr. Favre?
Well, I just want to make sure he gets credit for the time he's due on these cases, but
so do I, Mr. Favre.
Yeah.
Believe me, that's what this whole discussion is about.
Yeah, I'm looking at it right now, and
I think I've got it sorted out.
His Elk warrant's been in place since 22, waiting on him to come back from all the other states. His Greenwood warrant has been in place since August 21st of 25.
All right. No, nothing else, Judge.
All right. This time, the court will address the defendant, J.D. Comstock, personally and ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he personally would like to present.
Yes, sir, Your Honor. I just want to say that I've been waiting for 4 years to get this behind me, Your Honor, and I just would humbly request the court to run these all concurrent so I can get this state behind me and move on with my life and try to get out and be a productive member of society.
What are you facing down in Arkansas?
I'm on parole in Arkansas till 2032. I'm currently facing some charges out of Missouri. That's the cases I'll be going to after this, Your Honor.
Okay. Okay. But as far as you know, they haven't taken any action, a parole hold or anything out of Arkansas to have your case reviewed?
No, sir.
Okay. All right. Thank you for your statements, Mr. Comstock.
Yes, Your Honor.
We'll pronounce sentence in these cases at this time. Court will first address Elk County case number 2022 CR 51. Court hereby establishes count 1 as the base sentence in that case for the offense of attempted aggravated assault, a severity level 8, non-drug, person felony in which the defendant has a criminal history score of B, thus placing him in grid box 8B. The court hereby sentences the defendant to a term of 18 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed on that count. Regarding the additional offense of fleeing or attempting to elude law enforcement, a Class B misdemeanor, the court imposes 6 months in the Elk County Jail and runs that time concurrently with the time imposed on count 1 for an overall controlling sentence in that case of 18 months Department of Corrections custody. Court does find that the defendant was on parole out of the state of Arkansas at the time that this crime was committed. This court will run this case consecutively to any of the prior cases that were existing in the state of Arkansas at the time. Those would be Fulton County, Arkansas cases 2025 CR 17-101, Fulton County, Arkansas case number 25 CR 17-134, and Izard County, Arkansas case number 33 CR 18-71. Court will run the time in Elk County case number 2022 CR 51, concurrently with Butler County case number 2025 CR 156. The court makes a ruling that therefore makes Mr. Comstock eligible for a dual credit with Butler County case number 25 CR 156 in the amount of 209 days of additional jail time credit. So essentially, the correction on the base sheet would be 0 days would change to 209 days jail time credit on this particular case. Or does find that in grid box 8B, this is presumptive prison under Kansas law. There's been no departure motion before the court to otherwise seek an exception. This is a ruling that the court makes of 18 months commitment to Department of Corrections prison custody. Court will assess in that case $193 docket fee, $45 booking and fingerprint fee for a total of $238 total, which is immediately due and payable and collectible. And the court will waive bids assessments in that case. Now, before I move on to the Greenwood County case, I wish to inquire of the prosecuting attorney first. Is there any other sentencing related matter other than some general pronouncements that I'll make at the end of this case that we need to address, which are particular to the Elk County case? Ms. Gillette?
I don't think so, as long as, fingerprint appeal, we'll do that at the end, so.
Mr. Favre, anything in particular regarding the Elk County case?
No, Judge, thank you.
We'll move on to the Greenwood County sentence at this time.
Wait, did you say good time credit and post-release?
Yes?
Yeah, he did.
Just making sure. Okay.
Court will next address Greenwood County case number 2025 CR 150. We'll pronounce sentence in that case at this time. Court hereby establishes count 5 as the base sentence in this case for the offense of criminal possession of a weapon by a convicted felon, a severity level 8, non-drug, non-person felony, in which the defendant has a criminal history score of A, thus placing him in grid box 8A. The court hereby sentences the defendant to a term of 19 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed on that particular count. or on, it's the intention not to impose fines on any of the counts in this case. Moving on then to the additional offense. In count 1, interference with law enforcement, a severity level 9, non-drug, non-person felony, in which the defendant has a criminal history score of I, thus placing him in grid box 9I. The court hereby sentences the defendant to a term of 6 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. No fine is imposed on that count. The court will run the time on count 1 concurrently with the time imposed on count 5. The additional offense in this case is count 3, which is possession of marijuana, a Class B non-person misdemeanor. The court imposes 6 months in the Greenwood County Jail and runs that time concurrently with the time imposed on the other counts. Controlling sentence in that case, therefore, is 19 months Department of Corrections custody. This court will run the time in this case consecutively to Fulton County, Arkansas case 25CR-17-101, Fulton County, Arkansas case number 25CR-17-134, and Izard County, Arkansas case number 33CR-18-71. Furthermore, Mr. Comstock, this court is of the belief that when you wrong people of different counties, a different sentence is called for. These crimes are not the same. You had crimes involved, in this case, of criminal possession of a weapon by a convicted felon, always a serious matter. And I'll also note that that's fairly separate, distinct to what happened in the other case, which is attempted aggravated assault on a law enforcement officer. Therefore, this court will also run the time in the Greenwood County case 25CR-150 consecutive to the time imposed today in Elk County case number 2022-CR-51. This would result in an aggregate prison sentence imposed between the two cases of 37 months controlling. Court does grant the defendant in this Greenwood County case 128 days of accrued jail time credit. And counsel, that is separate and independent of the 209 days that was imposed earlier. As this is a consecutive case, it has separate, distinct jail time to be credited. The court will be assessing in this Greenwood County case a felony docket fee of $193, $45 booking and fingerprint fee for a total of $238. Bids assessments are waived in this case as well. The amounts in this case are declared by the court to be immediately due, payable, and collected. Court's already dealt, I think, fairly extensively with the issue of jail time credit. Comstock, at some point in the future, you may have the right to seek expungement or more of or one offenses that have been sentenced on today. If you have any questions about your right to someday seek expungement of any offense involved in these two cases, you can address those questions to a lawyer, and I'm sure get your questions answered. Under certain circumstances, a criminal defendant in Kansas has the right to appeal their convictions to an appellate court having jurisdiction. And if you are unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and to direct that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, the defendant has 14 days after these judgments in court to file any notice of appeal with the clerk of the district court of either Greenwood or Elk County, Kansas, as is applicable. Mr. Comstock, you do have the right to appeal these sentences if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Court will remand the custody of Mr. Comstock to the sheriff of apparently the Greenwood County Jail at this time until his custody can be transferred to the Department of Corrections, other appropriate authority. All right, I'm going to review my notes here, Council. We've covered a lot of ground. See if there's any sentencing related matter that I believe I need to address or readdress. I don't think so, except that I wanted to state for the record that the court has contemplated that there was perhaps a hold put on Mr. Comstock while he was in custody in Arkansas. However, it does appear that those would likely involve cases that are run consecutively in this case. Therefore, he wouldn't be entitled to additional credit for any of the Arkansas time, as these matters were run consecutively to all of those Arkansas cases. So the court has considered that, but rejects any additional jail time credit for that reason. All right. Ms. Gillette, are you aware of anything further that needs to be addressed in either the Elk County case or the Greenwood County case, which has been before the court here this afternoon?
The only thing I missed writing down was the number on count 5, which was the second count of conviction on the Greenwood case.
That was the primary crime here. Count 5 was the primary crime, 8A grid box, 19-month sentence.
Count 1. It was the second count of conviction.
Okay. Interference with law enforcement. Concurrent.
Thank you, Your Honor.
Mr. Favre, are you aware of other sentencing related matters which the court has not yet fully addressed?
I'd like to just refresh and make sure that my notes here are all correct. So the court has given him a cumulative sentence of 37 months between both cases. The cases are running concurrent to the Butler case. He has 209 days of credit additional given to him on the Elk case and 128 days, which was on the face sheet for the Greenwood case, because those sentences are consecutive to each other. Is that correct? Did I get that?
That's correct.
Okay. My only question would be then, on the Greenwood case, I think these cases all occurred in the weird pre-Irvin era. So I'm wondering if he should be getting credit on the Greenwood case of more time than he's currently getting. Should he be getting credit for a hold that was placed on him in Greenwood case pending his Butler case? So credit for Greenwood time that he would have accumulated while the hold was on him in Butler County. That would be my only question. As I understand that Irvin case, that's what the ruling was. And I know that the legislature's created a fix, but that was for cases that happened after May 23rd of 24. So this would be prior to that, I think. So I'm just making sure that I'm not misunderstanding that. Maybe Ms. Donovan can weigh in and tell me if I'm understanding that credit interpretation correctly.
All right. So when was this Greenwood warrant served on him in Butler?
Right.
The warrant was served on him on April 9th of 26. It was put in place August 21st of 25.
Well, I think Mr. Favre raises a good point. The credit that the court has granted him in Greenwood didn't start until February the 18th.
That's the time when he officially left Butler and went to Greenwood. But prior to that, I'm assuming he had a hold. And I'm looking at the case documents right now on Odyssey, and I'm trying to figure out when the Greenwood hold attached to him, and the warrant return says he was in custody as of 2/20/26, but he must have had a hold on him before that. So if it's the whatever date Jill said from August. I just want to know the official date so we can calculate that credit correctly. That's all. Jill, do you know when what was that date you gave as the date the warrant was attached to him?
The warrant issued 8/21/25. The warrant was served on him when he came here 2/18/26.
So was he subject to the warrant until he was served, Mr. Favre?
Yeah, that's what I'm wondering. I mean, I guess no. I would say no if he wasn't served until 2/18. But I guess did they just serve him that day? Yeah. I don't know. Well, if he wasn't served till 2/18, I guess that's the date, is how I would read it. I hope I'm reading that right. I don't know. Because the hold wouldn't have applied until 2/18.
Any of those days of controversy, he received credit for in Elk County, and Elk and Greenwood are running consecutively. He can't get credit for time for Greenwood County for any time he's getting credit in Elk.
Right. Okay, I see.
So I think that precludes your argument. It's a different way of looking at the issue, Mr. Favre, but I think the outcome is the same.
I think you're right. I think you're correct. Okay, that's it. Nothing further than thank you.
Ms. Donovan, do you see anything else this court needs to clean up?
No, Your Honor.
All right, thank you for your work on the case. All right, again, the court has remanded custody back to the sheriff's office until he can be transferred to the appropriate authority for his next step. Hopefully you can get all that resolved someday, Mr. Comstock, and maybe even have a firm date as when you might be able to achieve your freedom, especially if you're able to earn program credits or as much good time credit as you possibly can against these sentences. I hope you can do that.
Yes, sir, Your Honor.
All right. If there's nothing further, the Comstock matters will currently be in recess at this time, and this meeting may be ended for all.
And that's all she wrote, ladies and gentlemen. Thank you very much for hanging out with me tonight. It's been another one of those days. Had all the court cases going on. Oh my goodness. I'm all discombobulated. I can't find any of the stuff that I need. Nothing's popping up right. You know how it goes, ladies and gentlemen. I'm your lone wolf Oosel. I put these little court cases together for you, and I do it every single day of the week, and I'm gonna do it again tomorrow. So join me again. Same wolf time, same wolf channel. In the meantime, I've got a lot of names to read, and I want to start these credits up, so I'm gonna get those started right now. Thank you very much to my good friends Marty Duvall, Living Like a Cat, Northwest, Darth Steven, Living Like a Cat 3 times over, Darth Steven again, Northwest, Darth Steven again, Dixon is out there, Barry Adams. Wolfie, this is because I called OAKLEY Hesslink and I'm not even drinking. And I am on a bigger screen. Yeah, okay. You're on TV, you're on a bigger screen. You have no excuses there. But hey, thank you very much for the donation. Arr, Vegas Starlight. Arr. Darth Steven, Natasha Kitty, thank you all for the bits, the bots, the jewels, the jots, the super chats. Thank you all for being here and hanging out with me. I've got a hard stop tonight, so I'm just gonna say thank you so very much. I am your lone wolf Oosel. I have been here all night long to bring you these court cases, and we'll have some more tomorrow. For now, I am out. Rhonda will return.